So good morning. So we will continue with our discussion on succession. So last time we finished with the rule on defects and imperfections in the form of attestation or in the language used therein shall not render the will invalid. So long as there is substantial compliance, we have no problem. So the notarial will still be valid so long as there is substantial compliance, meaning as far as the pagination is concerned, okay lang na number yan even if the requirement is in letters. Okay, so let's go to Article 810. It says here, a person may execute a holographic will which must be entirely written, dated, and signed by the hand of the testator himself. It is subject to no other form and may be made in or out of the Philippines and need not be witnessed. So, Article 810 speaks of holographic will. The only requirement, okay, it says here must. Pag sinabing must, it means mandatory. Okay, like the word shall or will, mandatory yan. It is not merely discretionary. So it must be entirely written. So all of it must be written. There should be a date and signed. The one who write the date should be and sign the deed should of course the testator himself. Okay? Article 812 in holographic will. Okay, the dispositions of the testator written below his signature must be dated and signed by him in order to make them valid as testamentary dispositions. What does this mean, brothers and sisters? Let me highlight this for one. Okay, let's say the testator wrote a will. Eto, gumawa siya ng will dyan. Okay, September 1, 2020. Tapos hindi niya napirmahan yan. Okay? And then meron siyang nilagay, ay meron pala ako nakalimutan, sabi niya PS. I give my other my one property to A. Okay? So sabi diyan, the dispositions of the testator written below his signature, meron ng pirma rito, must be dated and signed by him in order to make them valid as testamentary dispositions. Meaning, kung meron pa siyang panibago dito, may PS siya, dapat pipirmahan niyo ulit yan, okay? At saka lalagyan niya ng date, September 1, 2020. That will make the dispositions below his signature will be valid. So, pag hindi niya yan pinirmahan sa baba, hanggang dito lang yung valid, hanggang nasa taas lang. Sa baba, it will become void. Okay? Yan ang rule pertaining to Article 812. Next. In the probate of a holographic will, when we say probate, basically the proceedings in the proceedings to determine whether or not the will is valid, ayan, is already before the courts. So it shall be necessary that at least one witness who knows the handwriting and signature of the testator explicitly declare, sasabihin, that the will and the signature are in the handwriting of the testator. Ay, ito sulat ni ano, to sulat ni ganyan yan. If the will is contested, meaning somebody is disputing the validity of the will, okay, what is the requirement? At least 3 of such witnesses shall be required. So yung mga kaibigan nyo, yung kapag-anak nyo, yung mga kapatid mo, sasabihin, ito yung sulat niya. Okay, if somebody is said, ay hindi niya sulat yan, maganda kasi yung sulat yan. Pangit ang sulat yan, bakit ang ganda-ganda niyan? Okay, so there 3 additional witnesses will be needed just to tell or explicitly say that that is the handwriting of the testator. In the absence of any competent witness, meaning walang nakakaalam ng kanyang sulat, okay, referred to in the preceding paragraph, and if the court deemed it necessary, expert testimony may be resorted to, meaning kukuha na dyan ng mga handwriting expert. Okay, but the handwriting expert, yung expert testimony is required only if there are no competent witness. Pag sinabing competent witness, they have direct knowledge on the handwriting of the testator. Okay, talagang nakita nila. So kung hindi mo naman nakita, parang feeling mo lang yan ay sulat niya, hindi ka competent witness because you have no direct knowledge. Okay? Article 813. when a number of dispositions appearing in a holographic will are signed without being dated, walang pirma pero hindi nilagyan ng date, and the last disposition has a signature, yung pinakahuli, and a date, such validates the dispositions preceding it, whatever be the time of prior dispositions. Meaning, brothers and sisters, ganito po yan. Okay, let me write this. Let's say, brothers and sisters, you made a disposition here. Ayan. Meron kang ginawang disposition dyan. Disposition, disposition. And then there's no signature and date. But it's your will and it's your handwriting. And then, let's say you made this one in 2018. And then in 2019, gumawa ka ulit. Ayan. Wala pa rin pirma yan. And then in 2020. And then you realized, ay, nakalimutan ko palang pirmahan. Kasi gumawa ka ng panibagong disposition, but wala palang pirma to. So you signed it, okay, and you put a date, September 1, 2020. Then it will validate all your prior dispositions. It's as if the dispositions were made on September 1, 2020. Okay, so that's the requirement in Article 813. In Article 814, in case of any insertion here, so halimbawa, meron kang in-insert dyan. Okay, let's say property 1, insert mo dyan. Cancellation. Okay, how do you cancel? Ganyan, pwedeng cancel yan, o kaya buburahin mo ganyan, o kaya isulat mo dyan, word cancel, erasure or alteration, buburahin mo, ayan, yan, yung isang provision lang. Okay, in a holographic will, the testator must authenticate the same by his full signature. When we say full signature, hindi lang basta-basta yung tinatawag nating marginal signature. Okay? So, ayan. Article 815. When a Filipino is in a foreign country, he is authorized to make a will in any of the forms established by the law in which he may be. Such will may be probated in the Philippines. Okay lang din naman yan. That is allowed. Article 818. Two or more persons cannot make a will jointly or in the same instrument. Bawal po ang same instrument. Okay? Either for the reciprocal benefit or for the benefit of a third person. Meaning, let's say you are already married or you are into a relationship with someone you think is your one true love. So, nagsumpaan kayong magmamahalan. Sabi nyo, patunayan natin na mahal natin ang isa't isa. Gumawa tayo ng will. And so you agreed, nilagay yan sa isang piece of paper. In front, sabi ni lalaki, I will that all my properties be given unto you as a sign of my love and loyalty. Ikaw naman, babae, mas mayaman, pipirma ka ba? Gagawa ka rin ba ng will mo at the back of the will made by the boyfriend? Sabi dyan, are you willing to say that I will that all my properties be given unto you upon my death? Yes, a sign of my love and loyalty to you. Pag pinirmahan mo yan, okay lang magpirmahan yan, okay lang din yan because it's not allowed under our jurisdiction. Joint wills are not allowed here, even if it's for the reciprocal benefit of the other person or for the benefit of a third person. Meaning, halimbawa, nagkaanak kayong dalawa. So, you prepared a joint will, okay, saying that all your properties will go to your son or the daughter. Same goes with the husband. So, parehas yung nangyari. Binigay niyo sa kanya. So, bawal pa rin yan kasi joint will yan. Okay, and joint will can also be made in one piece of paper. Parang nakalagay dyan ay, let's say, Inday, say Nicanor, and married to Inday. Nakalagay dyan si Inday, kayong dalawa. Both of you are executing the will for the benefit of each other. So kung sino yung unang mamatay, yung properties mapupunta sa kabila or sa kanyang anak. So that is joint will. Bawal po yan. Okay, bakit bawal? Kasi this one presupposes that there can be undue influence. Right? So halimbawa, ako yung lalaki, ay poor ako. Sasabihin ko, mahal na mahal kita, patunayan mo sa akin, mahal mo ko. Gagawa ko ng will, lahat pinibigay ko sa iyo. Ikaw naman, kung ikaw yung babae, you will be like influenced. Mahal mo rin yung lalaki. Kaya lang, you're not really willing to sign a deed like that. You will be forced now to prepare a will. So, ang mangyayari dyan, ayan, pipirma ka. So, that's the underlying condition for that. Article 819, wills prohibited by the preceding article, yung joint will, bawal. Executed by Filipinos in a foreign country, kahit na yan, allowed in other country, dito, bawal pa rin yan. Okay? Because our law will prevail over the law of other country as far as the execution of the will is concerned. Okay, yung law of the forum, we consider, although we consider that, pero of course, our law is supreme as far as we're concerned. So, draft a holographic will. So, I'll just post a requirement, the first assessment in Canvas regarding the drafting of your holographic will. So, witnesses to wills. Under Article 820, any person of sound mind, okay, pwedeng maging witness yan, so long as the person is sound mind and of age, not blind, deaf or dumb, and able to read and write, may be a witness to the execution of the will. Mentioned in Article 805. And Article 805, again, is about the notarial will. And remember, witnesses are only required in notarial wills. In holographic will, hindi yan necessary. Pero okay lang ba merong witness sa holographic will? Yes. But that witness, in case na meron, is a mere surplusage. Meaning, surplus lang yan, hindi naman talaga kinakailangan. Okay? Article 821, the following are disqualified from being witnesses to a will. Number 1, any person not domiciled here in the Philippines. Natural. In why such there is a requirement in number 1? Okay? Pag hindi taga dito, hindi pwede mag-witness. Of course, in the probate of the will, you will be needed. Right? Tatawagan ka ng korte, ito ba yung handwriting ni Nicanor? If you're not here, how can you go to the court and tell the court that that is the handwriting of the testator? So, bawal yan. Number 2, those who have been convicted of falsification of document, perjury, or false testimony, bawal. Sino itong mga to? We're talking about conviction here. It is not a requirement that yan ay final conviction na. So long as the person has been convicted, okay, that is sufficient for him to be disqualified from being a witness to a will. Bakit hindi pwede yung number 2? Kasi, simple lang, sinungaling kasi sila eh. So how can you trust a person who is a liar or who has lied and has been convicted for lying? Right? Yung isa, nag-falsify ng document, natural. Baka mamaya, pineke yung deed na yan, yung will na yan. Or perjury. Talagang nagsinungaling siya. Or provided a false testimony. Okay, so hindi pwede yan. They are disqualified from being witnesses to a will. Next, Article 822. If the witnesses attesting the execution of a will are competent at the time of attesting, when we say competent, they have the qualification, meaning they are of legal age, they are sane, they are not blind, deaf, and dumb. Okay, so their becoming subsequently incompetent shall not prevent the allowance of the will. So it's like same with the rule on supervening incapacity. So at the time of the execution of the will, sane siya, naging insane, so valid pa rin ang will. Okay? Article 823. If a person attests the execution of a will, this is very important, brothers and sisters. Okay? If a person attests the execution of a will, meaning, sasabi mo, ito talaga yung will, to whom or to whose spouse or parent or child a device or legacy is given by such will, such device or legacy shall, so far only as concerns such person or spouse or parent or child of such person, or anyone claiming under such person or spouse or parent or child, be void, unless there are 3 other competent witnesses to such will. However, such person so attesting shall be admitted as a witness as if such device or legacy had not been made or given. Anong ibig sabihin nitong Article 823, mga kapatid? Okay? Let us say you are a child of the testator. Anak ka ng testator. And then you are one of the witnesses. You were asked by your parent to be a witness to the will. Pumirma ka ngayon. Pag pumirma ka ngayon at nagbigay siya ng device or legacy, okay, hindi mo makukuha ang device or legacy na yan because that device or legacy is void unless merong other three competent witness. So kung halimbawa sabi ng tatay mo, gusto mo sa'yo na yung kotse, so other than you being a composer, binigyan ng kotse. Okay? Sabi niya, gusto mo ng kotse? Oo, sige, pirma ka dito sa will ko, sabi niya, as a witness. Pag ganon, sinabi niya, para hindi sumama ang loob ng daddy mo, pipirma po ako dyan, pero papirmahin mo dyan yung kailangan apat kaming witness. Okay? Kasi pag apat kayong witness, valid pa rin yung device or legacy. Pero pag tatlo lang kayo, yung device or legacy is void. Okay? But you are a competent witness nonetheless. So, ang rule na to, kung sakasakali, ikaw ay naging witness pero nagbigay ng device or legacy kanino? Sa asawa mo. Okay? Nagbigay ng device or legacy hindi sa iyo, sa asawa mo o sa magulang mo or sa anak mo. Okay? Hindi rin valid ang legacy or device. Okay, that is the requirement unless there are three other competent witness. So meaning dapat apat kayo. So kung apat kayo, yung binigay sa asawa mo, binigay sa magulang mo, binigay sa anak mo, okay, valid na. Okay, so that's the requirement in Article 823. Now, just to give you again an idea in applying this rule, if your parent or any other person is writing a will and then ask you to be a witness. So halimbawa, sabi ng tatay mo, gusto mo sa'yo na yung kotse, sige, ano ka rito, maging witness ka. Ay, nako daddy, ayoko po maging witness. Baka sabihin nila, ini-influensyahan kita. Okay, pwede po bang si ate na lang at saka si kuya? You know what will happen if your ate and kuya became a witness to the will and your parents also gave them something, a device or a legacy? Do you think they will get the property? Of course not. Okay, because there is such requirement under Article 823 that once you attest to the execution of a will and you were given a device or legacy, you will not be able to get the device or legacy because that device or legacy is void unless, of course, there are other three more competent witnesses. Okay? Revocation of wills and testamentary dispositions. So Article 828. A will may be revoked by the testator at any time before his death, natural, because he cannot do the revocation after his death. Any waiver or restriction of this right is void. Article 829, that is self-explanatory na rin. A revocation done outside the Philippines by a person who does not have his domicile in this country is valid when it is done according to the law of the place where the will was made. Ang tawag natin dyan, law of the forum. Or according to the law of the place in which the testator had his domicile at the time. And if the revocation takes place in this country when it is in accordance with the provisions of this law, of this code. So revocation is more or less allowed in our jurisdiction. Article 830, no will shall be revoked except in the following, by implication of law. So meaning, there's a law saying that all wills are no longer valid. So kung invalid na ang mga wills, you think you can enforce it? Of course not. So the will is revoked by implication of law. Okay, well, express yan, pero it can be also implied if the provisions of that will impliedly disallowed or revoke the will. Okay? Number 2, by some will, codicil or other writing executed as provided in case of wills. Meaning, you can write another will. Let's say, in your first will, you have testamentary dispositions. Let's say 1, 2, and 3. Binigay mo yung number 3 sa best friend mo. Eh ngayon, hindi na kayo BFF. Okay? So you can actually revoke your testamentary disposition as far as the third disposition is concerned by some will. Gumawa ka ng will. Just get a piece of paper. Lagay mo doon, I am revoking my testamentary disposition or I am revoking my will altogether, yung buo. Okay, which I executed on this period. So, pwede yan. Hindi lang yung pwede yung buong will or any disposition that is revocating. Okay? Or codicil. It's also a piece of paper saying that expressly you are revoking the will. Number 3, by burning, sinunog mo. By tearing, pinunit mo. Canceling, crossing out the whole paper. Okay? Or write the word cancel. Okay, or obliterating. Talagang obliterated yung the document. Okay, but the requirement is that there must be an intention of revoking it. If there's no intention of revoking it, then okay, it can so long as it can be established, yan ay valid. So by burning, tearing, canceling, or obliterating the will with the intention of revoking it, by the testator himself, siya mismong gumawa niya, or by some other person in his presence. Pinagawa niya yan sa ibang tao and by his express direction. Oy, nakikita mo tong papel na to, ito yung aking will. Pakisunog nga. Kasi nire-revoke ko na yan. That is the requirement under Article 830. There is an intention. Ito yung will ko, pakipunit nga to kasi i-revoke ko na yan. Pag sinabing walang revocation, there's no intention, then so long as it can be established, valid pa rin yan. Okay, so same requirement yan. If burned, torn, cancelled, or obliterated by some other person without the express direction of the testator, kahit ikaw sinunog mo yan, or pinunit mo yan, kinancel mo yan, obliterate, or inobliterate mo yan, pwede pa rin yan, basta pwede pa rin establish. Kung wala naman ako sinabi, sa'yo na yan ay nire-revoke na. Okay? So, what else? Next. Article 838. No will shall pass, either real or personal property, let us proved and allowed in accordance with the rules of court. So, lahat ng will dadaan sa korte. Probate ang tawag na dyan. Okay? It must be proven. And then the testator himself may, during his lifetime, petition the court having jurisdiction for the allowance of the will. Pwede yan. Ang probate naman kasi is merely determination of the validity of the will. And of course, determining whether or not the testator is of sound mind during the execution of the will. At saka determination kung siya ay of legal age during that time. And kung siya ay sane. Okay, those are just the requirement in Article 838. Article 839. The will shall be disallowed in any of the following cases. Number 1, if the formalities required by law have not been complied with. Ano yung mga form na yan, formalities? In notarial will, walang three witness. Okay, hindi yan pwede. Disallowed yan. In holographic will, hindi yan dated. Hindi yan written by the hand of the testator entirely. Hindi yan signed by the testator. Of course, the will be disallowed. Number 2, if the testator was insane, natural. There's no consent or otherwise mentally incapable of making a will at the time of its execution, it will never be allowed. Number 3, if it was executed through force, pinwersa ka, gumawa ka ng will, dahil kung hindi, papatayin kita. Okay, or under duress. Merong nakatutok na baril sa ulo mo. Or the influence of fear, papatay namin si ganyan. Or threats, hindi ka nasisikatan ng araw. Okay? Hindi pwede yung will. Number 4, if it was procured by undue and improper pressure and influence on the part of the beneficiary or of some other person. how can undue and improper pressure and influence be committed against a person? Okay? Kung halimbawa anak ka, kukonsensyahin mo yung magulang mo. Kung talagang mahal mo ko, gumawa ka ng will, sabihin mo, yan ay binibigay mo sa akin lahat. Dahil kung hindi, magpapakamatay ako. Or iiwanan kita. Okay? So, in that case, the will shall be disallowed. Number 5, if the signature of the testator was procured by fraud. Kinausap mo yung mami at daddy mo, gumawa ka ng will, ikaw sumulat. Mami, daddy, ginaya mo yung sulat nila. Requirement po ito ng teacher namin kay Sir Vic. Gumawa daw po kami ng will ng yung parents daw po, pinapagawa yung will, tapos pinapalagay lahat ng property sa ano. Ano to, requirement po namin to para pumasa kami sa klase namin. So, yung parents mo naman, they sign the document without really intending that the instrument is their, yan. Okay? O kaya pwedeng yan, waiver yan. Sabi nyo, waiver lang po ito, mami, daddy. Pinirmahan naman nila because they trusted you. Tapos hindi pala. So number 6, if the testator acted by mistake or did not intend that the instrument he signed should be his will at the time of fixing his signature thereto. So ito rin yung example ko kanina. Hindi naman niya intended that your parents, yung parent nyo, that is their will. Kaya lang, you let them realize na sinasabi nyo na yun ay kanilang will. That is merely a requirement from the school, when in fact it's not. Or even if it's really a requirement, they did not intend that the document they signed is their will. So yan ay hindi pwede. Okay? So Article 840, institution of heir, this is very simple. This is just an act by virtue of which a testator designates in his will the person or persons who are to succeed him in his property and transmissible rights and obligations. So nilalagay niya dyan kung sino yung kanyang pagmamanahan. Okay? So if your name is mentioned in the will, then you are instituted. That act is called institution. Article 841. A will shall be valid even though it should not contain an institution of an heir, or such institution should not comprise the entire estate, and even though the person so instituted should not accept the inheritance, ang tawag natin yan, repudiation, or should be incapacitated to succeed. In such cases, the testamentary dispositions made in accordance with law shall be complied with, and the remainder of the estate shall pass to the legal heirs. Remember our discussion on the legal and intestate succession. Okay? Ano po yung isa sa mga provisions na pinag-usapan natin doon? Okay? If there is no instituted heir in the will, valid pa rin yung will, but the properties will be distributed in accordance with intestate, with legal or intestate succession. So parang ang specific example ko doon, gumawa ako ng will pero wala akong sinabihan kung sino yung magmamana. I will that all my properties be administered or be managed by my brother upon my death. So I did not say anybody who will inherit my properties. And so therefore, the institution of my brother in the will is merely that of an executor or an administrator, because wala naman ako sinabi na mapupunta sa kanyang property. So valid pa rin ba yung will? Yes. Okay, what will happen now to my properties? Of course, it will be disposed of under legal or intestate succession. Article 842, disposition of estate. There is this one question before by one of your classmates. Sabi niya, paano kung walang tagapagmana yung tao? Kanino mapupunta yung property? This is the answer. One who has no compulsory heirs, nag-iisa sa buhay, may dispose by will of all his estate or any part of it in favor of any person having capacity to succeed. Basta wala siyang tagapagmana. Wala siyang magulang, wala siyang anak, wala siyang kapatid, wala siyang pinsan, wala siyang tito-tita, wala siyang first cousin, second cousin, etc. Kawawa naman siya. Okay? All of his properties he can dispose. He can give it to any person basta merong capacity to succeed. Sino nga yung walang capacity to succeed? Ito yung, number one, enemies of the state. Right? Ito yung mga dead person. Ito yung mga fictional characters. Ito yung later di-discuss natin, ito yung mga pare who heard the last succession. The last confession of the testator. Okay? So, hindi pwede magmana yung mga yan. So, basta pwede magmana, pwede yan, valid yan. Okay? Kung nag-iisa lang siya at hindi niya dinispose ang kanyang property in accordance to his will, then the person who will inherit the property is the state. One who has compulsory heirs, kung meron naman siyang compulsory heirs, pwede niyang i-dispose lamang, may dispose of his estate, provided he does not contravene the provisions of this code with regard to the legitimate of said heirs. Meaning, ang extent only that you can dispose is the free portion. Article 843, that the testator shall designate the heir by his name and surname, and when there are two persons having the same names, he shall indicate some circumstance by which the instituted heir may be known. So halimbawa, Juan de la Cruz 1, Juan de la Cruz 2, or Juan de la Cruz Jr. or the third. Okay, that's the some circumstance. O kaya anak ni ganito. Okay, anak ni Vic, anak ni Benjamin, anak ni Albert. Okay, so basically that's indication of some circumstance. Or one who is studying in the FEU taking BSA. Yan ang mga circumstance na yan. Even though the testator may have omitted the name of the heir, hindi nabanggit, should he designate him in such manner that there can be no doubt as to who has been instituted, the institution shall be valid. Remember our previous examples nung imperfect descriptions. Ang nag-iisa kong apo, alam na, there's no doubt as regards to that if nag-iisa lang yung kanyang apo. Pero kung halimbawa, sinabi niya, pinaka-sexy kong apo, 5 yung apo niya, and we cannot determine who among them is really sexy, or even if they are, it may seem that they are not sexy, hindi natin masasabi, because again, it will depend on the person who's looking. Right? So kung wala, no one shall inherit. An error in the name, surname, or circumstances of the heir shall not vitiate the institution when it is possible, in any other manner, to know with certainty the person instituted. Kahit naman yung pangalan, halimbawa, ang anak ni Albert, si Zach, hindi naman anak ni Albert si Zach, kung hindi anak siya ni Benjamin. So in that case, valid pa rin naman yan. Kasi kilala naman siya eh. Okay? If among persons having the same names and surnames, there is a similarity of circumstances, parehas. Let's say both are taking accountancy, both are studying at Far Eastern University, okay? Even with the use of other proof, the person instituted cannot be identified. Hindi malaman kung sino sa kanilang dalawa. None of them shall be an heir. No one shall inherit. Right? So, yun ang magiging ano dyan. Kaya nga, sabi ko sa inyo, if your lolo or lola or some other person would like to give you, there's no need for them to describe you. You just ask or you just tell them, pwede ba isulat mo lang ang pangalan ko, utang na loob. Okay, wag mo nang pahirapan ang korte sa pagdetermine kung sino ba yan. Right? In the same way, also, applies to you. Pag gagawa ka, wag ka na magpabebe. Sasabihin mo, nag-iisa kong BFF. Wag mo nang sabihin nag-iisa kang BFF. Marami kang kaibigan. And for all we know, all of them think that you are their BFF. Ikaw, isa lang sa kanila. So, if nobody can say who is really your one true BFF, then none of them shall inherit. Yan yun. Okay? Article 845. Every disposition in favor of a known person shall be void unless by some event or circumstances his identity becomes certain. However, disposition in favor of a definite class or group of persons shall be valid. No problem as far as the second part is concerned. Let's go to the first part. Example. There is this person, let's call her Inday. Okay? Nasagasaan si Inday. Hit and run. And then there's this person who helped her, brought her to the hospital hanggang maging okay siya. Ngayon si Inday, gumawa siya ng will. Sabi niya, I am giving 1 million pesos to the person who helped me. Okay? If napatunayan na si Nicanor ang tumulong sa kanya, then that disposition is valid. But if there's no way to determine who is the person who helped her, then no one shall inherit. Ganun po yan. Okay, so if Nicanor came forward saying that he was the one who helped Inday during that time, edi siya yung magmamana. Kasi nakilala siya by some event or circumstance. And his identity became certain. Article 846. Heirs instituted without designation of shares shall inherit in equal parts. So kung silent, equal po yan. Article 854. The preterition or remission of one, some, or all of the compulsory heirs in the direct line, whether living at the time of the execution of the will or born after the death of the testator, shall annul the institution of heir. Ano pong ibig sabihin ng preterition? Preterition, okay, is the omission of your name as a compulsory heir. So halimbawa, ang magkakapatid A, B, and C. Pagkatapos, binanggit lang sa will ng kanilang magulang si A and B. In that case, C is preterited or omitted because he is a compulsory heir in the direct line. Okay? What will be the effect of that? It shall annul the institution of heir, meaning yung pagbanggit kay A and B is annulled in the will. Okay, meaning it's as if it's A, B, and C. That's the effect of that. But the devices and legacies, yung mga binigay na real property at saka personal property shall be valid insofar as they are not inofficious, meaning they do not impair the legitim of the preterited or the omitted heir. Kaya hindi siya sobra. If the omitted compulsory heir should die before the testator, namatay siya, hindi siya binanggit sa will, the institution shall be effectual. Valid ang institution kay A and B without prejudice to the right of representation. Meaning, valid ang institution kay A and B, pero kung merong anak si C, okay, the child or children of C shall represent C in the proceedings. Okay, so meaning they will inherit by virtue of right of representation. Article 855. The share of a child or descendant omitted in a will must first be taken from the part of the estate not disposed of by the will, if any. So, kukunin muna yung property sa halimbawa, A and B, plus C, hindi nabanggit si C. So, yung share ni C, okay, ay kukunin muna sa free portion. Paano if it is not sufficient? Let's say, ang kailangan na makuha is 25%. Pero yung free portion, 10% na lang. Okay, saan kukunin yung 15%? So, ang mangyayari dyan, proportionally from the shares of the other compulsory heirs. So, if 25% is needed, 10% is left in the free portion, yung 15% shall be, okay, in deficiency shall be taken from the share of A and B, who were able to get their share in the properties. Article 856, voluntary heir. We're talking about devices and legatees. Okay? Who dies before the testator transmits nothing to his heirs. Pag voluntary heir ang namatay, yung anak nila hindi makukuha yung device, real property, or legacy / personal property na bigay na testator. wala pong right of representation dyan. Unlike in compulsory heir, if the compulsory heir dies, ang kanyang descendant ang magmamana for and in her or in his behalf. Okay? A compulsory heir who dies before the testator, ito yan, a person incapacitated to succeed, and one who renounces the inheritance, repudiates, shall transmit no right to his own heirs except in cases expressly provided for in this code. So merong mga requirement lang dyan. Meron lang specific cases. Okay na pwede. 857 is merely substitution. So it's the appointment of another heir so that he may enter into the inheritance in default of the heir originally instituted. So I am designating A as my heir. In case of death, kay B mo pupunta. So that is this substitution. Conditional testamentary dispositions and testamentary dispositions with a term. The institution of an heir may be made conditionally or for a certain purpose or cause. Okay, so example then, previously, on the yung magmamana ka ng 1 million pesos just for you to be able to get the you get the 1 million pesos if you top the CPA board examination. So that is the requirement in Article 871. So pwedeng conditionally or for a certain purpose. Pag naka-graduate ka or cause. Okay, let's say you will get 1 million pesos kung ikaw ang makaka-discover ng cure for COVID-19. So, ayan yan. Okay, dispositions yan with condition. Article 872, the testator cannot impose any charge, condition, or substitution whatsoever upon the legitimes prescribed in this code. So, for purposes of our discussion, okay, ito, again, the testator cannot impose a condition upon the legitimes. So, kung ikaw ang tagapagmana, your parent cannot put a condition on that because that is a legitime. Remember, pag ikaw ay compulsory heir, you are entitled to the legitime. So therefore, for no charge or condition or substitution can be made by the testator himself. Okay? Kung yan ay gawin man ng magulang mo, the same, under the rule, the same shall be considered as not imposed. So meaning, halimbawa, sabi ng parent mo, that you will only receive as you are a compulsory heir because you are a child. Tapos sabi niya, magmamana ka lang sa akin kung ikaw ay papasa sa CPA board examination. So even if your parent will impose that condition on your legitime, okay, that's fine. You don't need to be scared or anything because under Article 872, sabi dyan, the same shall be considered as not imposed. So meaning it's as if there's no condition. Okay? So Article 873, impossible conditions and those contrary to law or good customs shall be considered as not imposed and shall in no manner prejudice the heir, even if the testator should otherwise provide. When we say impossible conditions, these are conditions which are impossible. Example, tatanggapin mo lang yung property na to kung hindi ka mamamatay. That's an impossible condition because everyone, one way or another, shall die. Okay? Another impossible condition, bibigyan kita ng property kung tatalon ka sa building 100 floors, pag buhay ka, sa'yo yun. That's an impossible condition because we know that the time that you have tumalon ka doon sa building na yon, you will certainly die. So that's an impossible condition. Okay? Sinabi ng testator, bibigyan ka lang ng ganitong property kung ikaw ay makakalipad. Of course, you cannot fly. even if you believe you can fly. Okay? Sabi ng testator, bibigyan lang kita ng property if you can touch the sky. Even if you believe you can fly. Even if you believe you can touch the sky. Impossible condition yan because you cannot really touch the sky. And those contrary to law, okay, or good custom shall be considered as not imposed. Example ng contrary to law. Bibigyan lang kita ng property kung mabebenta mo to ng yung 1 kilo ng shabu. That is contrary to law. Right? Bibigyan lang kita ng itong kotse, bibigyan kita ng 1 million, mapapamanahan kita kung papatayin mo si ganito, yung aking number 1 enemy. That is contrary to law. Or good customs. Ikaw ay isang Muslim, bibigyan lang kita ng bibigyan kita ng 1 million pesos na mana kung ikaw ay kakain ng baboy. Or you are, let's say, a kapatid sa Iglesia ni Cristo. And the testator said, bibigyan ka lang niya ng mana kung ikaw ay kakain ng dinuguan. That is contrary to the good customs of the Iglesia. So how will we treat those types of conditions? Under Article 873, they shall be considered as not imposed and shall in no manner prejudice the heir, even if the testator should otherwise provide. So meaning, even if they will set those conditions in the will, okay, huwag kang mag-alala kasi the law provides that those types of conditions, even if indicated in the will, are considered as not imposed. So parang wala lang. So ibig sabihin, kahit hindi ka tumalon sa building, kahit hindi ka lumipad, okay, kahit di mo ibenta yung shabu, kahit hindi mo patayin yung pinapapatay niya sa'yo, kahit di ka kumain ng baboy, kahit di ka kumain ng dinuguan, okay lang yan, mamanahin mo pa rin siya. And that's in compliance with Article 873. Okay? So, table of legitim and intestate share. So basically, this is the table that we will be using in determining the appropriate share of each tagapagmana. Okay? So on the first column, you can see the surviving heir, sino yung mga naiwan. On the second column, the middle is the legitim. Kung merong will, ito yung magiging rule in the distribution of the property. Kung walang will, doon tayo sa intestate share. Okay? Mapapansin nyo, brothers and sisters, in legitim, there's always a free portion. Because that free portion, again, is that portion that can be disposed of by will by the testator. Sa intestate share, wala pong free portion dyan. Everything shall be distributed. Okay, so that's basically the difference. So let's take a look at this table of legitim. So halimbawa, merong ang mga survivors, illegitimate children at saka yung surviving spouse. Okay, yung anak sa labas at saka yung asawa ang naiwan, paano yan i-distribute? So ang hatian, if merong will yung namatay, 1/3 kay IC, illegitimate child, 1/3 kay asawa, yung 1/3 pwede siyang ipamigay ni testator kahit kanino. Pwede ba niyang ibigay yan kay illegitimate child? Yes. Pwede niyang ibigay kay surviving spouse? Yes. Pwede ba niyang ibigay kay magulang? Yes. Remember, sa rules natin, kung sino yung mga compulsory heirs. Now, what if the testator, the decedent died without having a will? How will his properties be distributed? Eh di kalahati ang mapupunta sa illegitimate child, kalahati sa asawa. Remember mga kapatid, merong pababa, kaya wala yung magulang dyan. Later yung magulang, meron din siyang share pagdating sa Kaya lang dito, sa scenario na to, the only surviving heirs are the illegitimate children and the surviving spouse. So hati sila, dalawa lang kasi sila na nabuhay. So what if the survivors are the illegitimate children, the surviving spouse, and the illegitimate parents? Ayan. Ano na hatian pag merong will? Kalahati ang mapupunta sa legitimate parents. Remember, ang rule on compulsory heir. Ang number 1 rule, legitimate children muna. Number 2, in default of the foregoing, kung walang legitimate children, ang magmamana, legitimate parents. Kaya, ang legitimate parents, half. Okay? 1/4 will go to the illegitimate children and 1/8 with the surviving spouse. The free portion that can be disposed of by the testator is only 1/8. Okay? Paano naman kung halimbawa walang will? How will the properties of the descendant be distributed? Again, kung walang descending, mag-a-ascend siya. Kaya si legitimate parent, 100 ang kanyang, 1/2 ang kanyang makukuha. 1/4 kay legitimate child, 1/4 kay surviving spouse. So, ganito ang rule na pinag-uusapan natin. Okay? So, are you required to memorize this one? Well, as far as I'm concerned, for purposes of you passing my course, you have to be familiar with the sharing. Okay? So, kung sinabi ko paano hatiin to, dapat alam mo yan. Kasi ito ay applicable sa ating tunay na buhay. Pag tinanong ka, magkano kaya yung share na ganito? Ang sasabihin mo kagad, sino ba yung mga tagapagmana? Okay? Meron bang will yan o wala? That's how you answer questions. So, pag sinabi niyang wala, sino yung tagapagmana? Legitimate parent at saka legitimate child. Kung walang will dyan, intestate share yan, 1/2 sila. Paano kung halimbawang merong will? Kung merong will yan, since walang legitimate child, legitimate parent, akit yan. So, kalahati sa kanya. 1/4 lang yung sa legitimate child, tapos 1/4 free portion. Okay? So, yun ang mga rules natin. So, you have to be familiar. Paano kung halimbawa, on the second row, ang mga nabuhay, naiwan, legitimate parents at saka surviving spouse, wala siyang anak. Under the rules of legitim, kalahati ang mapupunta sa legitimate parents. Bakit kalahati? Kasi walang pababae. Okay, so 1/4 lang kay asawa, 1/4 kay sa free portion. Paano kung walang will? Intestate sharing yan. Legal or intestate yan. So how will the properties be distributed? Kalahati kay magulang, kalahati kay asawa. That's the rule. Okay? So you have to be familiar with this one. Kung ang survivors, legitimate child alone, 1/2 sa legitim, yung 1/2 free portion. Meaning, dito, legitimate child lang, walang surviving spouse, walang illegitimate child. Okay? So yung kalahati sa kanila na lahat, yung kalahati free portion. Pwedeng ibigay yan ng testator kahit kanino. Pwede ba niyang ibigay dun sa isang anak lang? Pwede. Pwede ba, magiging device or legacy yan. Pwede ba niyang ibigay yung kalahati na to sa sa favorite professor niya sa tax? Pwede. Okay, kahit kanino. Pwede ba niyang ibigay sa boyfriend or girlfriend? Pwede. Okay? Kasi free portion yan. Basta hindi sila disqualified from or there is no incapacity. Pag intestate share, okay, legal or intestate, namatay ng walang will, natural, since ang mga naiwan lamang ay yung mga legitimate children, 100% of the properties will be given to all legitimate children. Hati-hati sila, pro indiviso. Okay, pag legitimate parents, ayan, ang nabuhay, kalahati sa kanila, wala kasing pababa. So, kalahati sa kanila, 1/2 free portion. Kahit kanino pwede ibigay. Pag intestate naman, lahat mapupunta sa magulang. Okay, illegitimate parents alone. Sabi natin, merong legitimate parents. Sino yung legitimate children muna? Legitimate children, if your parents are married, you are a legitimate child. If you are a legitimate child, then your parents are your legitimate parents. Yung illegitimate parents naman, hindi legitimate sila, meaning your parents are not married. But if they are alive, ayan, kalahati ang makukuha nila kung gumawa ka ng will. The other half is free portion. Kaya nga kung halimbawa mga kapatid, okay, hindi ka sala magulang mo, ayan, the other half, you can freely give this one to the parent who took care of you. Ang nag-alaga sa'yo, ang nagmahal sa'yo. Okay? So, ayan. Kung wala naman mga kapatid na will, lahat ng properties will go to the illegitimate parents. So, just to give you an idea on how you can possibly distribute your properties in case that you are or you came from a broken family, tapos iniwan ka ng either nanay or tatay mo. Okay? Ganito po yan. Isa kang anak, Nanay, tatay, hindi sila kasal, pinanganak ka. Iniwan ka ng tatay mo or nanay mo, kahit sino sa kanila. Pag ang anak ay namatay, yung lahat ng properties mo, okay, intestate yan, lahat mapupunta sa kanilang dalawa. Hati sila. Papaano kung namatay na yung nag-alaga sa'yo? Halimbawa, nanay mo, namatay na. So, meron kang illegitimate father. Namatay ka din. Yung lahat ng properties mo, mapupunta sa kanya. Okay? Same goes if ang nang-iwan sa'yo ay nanay, ang nag-alaga sa'yo yung tatay, okay? Namatay yung tatay mo, so magiging tagapagmana mo yung nanay mo na nang-iwan sa'yo. Pag ikaw ay namatay, lahat ng properties mo mapupunta sa kanya. Just imagine, iniwan ka niya, pagkatapos siya pa yung magmamana. Ang point ko dito, you can actually write a will. Okay? So, yung free portion, ibigay mo doon sa taong nagmahal sa'yo. Yung sa taong nag-aruga sa'yo. Yung taong nag-alaga sa'yo. At binigay ang lahat para sa'yo. Okay? You just have to think about this kasi nga, pag yan ay hindi mo ginawa, well, parehas lang din naman kahit legitimate parents dito. Oh. Kung iniwan ka ng tatay mo or nanay mo, tagapagmana mo pa rin sila, compulsory heir mo pa rin sila pag wala kang descendant. So the only way you can protect the one who took care of you is for you to give the free portion to them. Although, meron pa tayong rule later on how you can possibly distribute your properties. Okay, meron tayong rule on disinheritance. So here, surviving here, papaano kung ang nabuhay lamang yung surviving spouse lang? Wala kang anak, wala kang magulang. Okay? Ayan. 1/2 or 1/3. Bakit ang rule ay 1/2 or 1/3? Ganito po kasi yan. Okay? 1/2 yan kung kayo ay matagal lang mag-asawa. Pero kung kayo ay bago mag-asawa pa lang, 3 months or less, ang tawag dyan, in articulo mortis. Okay? Example ng in articulo mortis. Halimbawa, 99 years old na ako, and then I met someone, let's say, 18 years old. Tapos, feeling ko siya na yung one true love, so nagpakasal kami. Do you think an 18-year-old will love me if I am a 99-year-old man? Of course not. So, most likely, pinakasalan lang ko dyan because of my status or my money. So, if I die within the 3-month period, only 1/3 will be given to the surviving spouse. Pag yan ay legitimate, kaya gumawa ako ng will. The other portion, the 2/3, is the free portion. Pero kung matagal ko na siyang asawa, let's say 5 years, okay, hindi na siya 18 years old, 23, let's say ganon. 1/2 ang mapupunta sa asawa ko. Yung 1/2, pwede kong i-dispose yan, pwede kong pamigayan kahit kanino. Pero kung halimbawa wala akong will, everything will go to the surviving spouse alone. Right? Yan ha. So, kung merong mga manliligaw sa inyo na matandang-matanda na, pag-isipan niyang mabuti yan. Just imagine ha, if you wala siyang kamag-anak, joke lang yan. But of course, you have to really consider not yung feelings mo and everything. Okay? So, legitimate children or descendants alone, 1/2 legitimate, 1/2 free portion, intestate all. Papaano mga kapatid kung one legitimate child or descendant at saka surviving spouse? Since may pababa, 1/2 kay anak, 1/4 kay surviving spouse, free portion, 1/4. Pag intestate share, 50-50 sila. Okay, so basically, these are the rules. So, yung kanina, dito po, last row, isa yung anak, nabuhay, asawa din. Dito, 2 or more children ang nabuhay at saka asawa. Iba yung sharing. Kanina, 1/2 ang mapupunta sa anak, 1/4 sa asawa, 1/4 free portion. Intestate, 1/2, 1/2. Paano pag dalawa or 2 or more ang anak? 2 or more legitimate children, may asawa. Okay? Yung kalahati pa rin mapupunta sa mga pababa, legitimate children. But all of them shall divide the property according to the number of children. So kung 5 yung anak, divided by yung 50%, the 1/2 shall be divided by 5. So effectively 10% ang makukuha ng bawat isa. Kanina, kung isa lang yung anak, kalahati sa'yo na lahat yan. Kaya kung may kapatid ka, yung kalahati sa'yo mapupunta, sa inyong magkapatid, mapupunta yung kalahati, so hati kayo dun sa kalahati. And then the surviving spouse will get equal to the share of one child. So kung dalawa kayong anak, di ba kalahati kayo dito, 1/2. Okay, sulat natin. So parang ganito po yan. So let's say 1 million peso, 1 million, okay, 1 million. Dalawa kayong magkapatid. So 500,000 ang makukuha. So divided by 2, each child will get 250,000. Right? So kung yung anak ay si A, 250 sa kanya, kay B, 250 rin. Eh si surviving spouse, 250 rin siya. So yung free portion, 250,000. For a total of 1 million pesos. Pag intestate share, how will the properties be divided? Kanina, ang sharing natin pag intestate, kalahati kay legitimate child, kalahati kay surviving spouse. Dito papaano kung dalawa yung anak? Consider spouse daw as one legitimate children. So in our previous example, dalawa yung anak, A and B. Si SS, surviving spouse, shall be considered as one spouse. So 1 million divided by 3. So each will get 333,333. That's the rule on the distribution of the properties. Okay. Next. What if ang survivor ay asawa mo lang at saka yung mga kapatid? Wala nang magulang, wala ring anak. So 1/2 ang pwedeng i-dispose sa testate. Gumawa ng will. Kalahati, legitimate yan, hindi mo pwedeng galawin yan, kay naka-reserve yan kay surviving spouse. Okay? Tapos yung 1/2 free portion. Yung brothers and sisters, not entitled to anything since they are not compulsory heirs. Panggulo lang sila. But the testator may choose to give them something out of the free portion. Okay, huwag niyong kakalimutan. Remember the rule on compulsory heirs. Sino nga yung compulsory? Legitimate children, pababa. Pag wala yung pababa, paakyat. Okay, we're talking about We're talking about legitimate here. Ayan, pinag-uusapan natin. So, merong compulsory heir. Pababa muna legitimate children. Pag wala, aakyat. Legitimate parents. Sino pa yung surviving spouse at saka illegitimate child? Meron bang brothers and sisters doon? Wala. Kaya hindi sila magmamana. Now, kung ikaw ay merong asawa, wala kang magulang, wala kang anak, pero may kapatid ka, anong gagawin mo para sila magmana? Eh di yung free portion, ibigay mo sa kanila. Kasi kung hindi mo ibibigay yung free portion, wala silang makukuha dyan. Okay? Although pwede pa rin sila makakuha under, di ba sabi natin, halimbawa binigay mo yung 1/2 sa asawa mo. Tapos yung 1/2 free portion dapat, pero you failed to provide kung sino yung magmamana dyan. So yung 1/2 free portion will be distributed in accordance with legal or intestate. Okay, so ganun yan, kaya magiging mixed succession siya. So ano ba yung legal, yung intestate share? If the survivors are the surviving spouse and the brothers and sisters. So yung kalahati mapupunta pa rin sa asawa, okay? And then the other half shall be given to the brothers and sisters. So magmamana siya sa intestate share. Yung kapatid mo, tagapagmana pa rin sila. Pero kung halimbawa gumawa ka ng will, okay, ayan, bigay mo na sa kanila para sila makakuha, para maliwanag siya. Okay? So, activity, assumptions. Total property is 1 million. Legitimate child is survived with one parent. Free portion is given to the legitimate child. Okay? So, isang legitimate child, isang asawa ang nabuhay. So, magkano ang hatian sa testate and intestate share? So, saan tayo pupunta? So, dito tayo. Right? 1 LC, surviving spouse, 1/2, 1/4. Tapos 1/4 free portion. Pag intestate, 1/2, 1/2. Okay, sagutin natin ang exercise. So, 1 million dito. So, sa test state tayo, sa test state. Let's go to test state. Okay, test state. Test state. So, 1 million. Ano ang sabi natin pag test state? Kalahati, 1/2 sa legitimate child. So, 500,000. Magkano sa surviving spouse? Okay, 1/4. So, 250,000. Yung 1/4, 250, anong sabi dito? Free portion in number 3 shall be given to the legitimate child. So, plus 250 siya doon. So, magkano yung share niya ngayon? 750. Si wife, 250. So, that's how the properties are to be divided according to the rule on legitim. Paano naman kung intestate yan? Anong sabi natin? Kalahati-kalahati. O hindi yung mangyayari dyan. Okay, pag intestate share, intestate, ano mangyayari? So, 1 million, kalahati mapupunta kay legitimate child at saka surviving spouse. So, dito, 500,000. Dito, 500,000 also. Okay, napakadali nito so long as you know how to compute. And of course, you have to be familiar with the rules on legitim. Okay? O yan ha, meron na tayong level up, meron na sulat-sulat. So, yun. So this is actually one of the important things that you have to consider and of course understand in the application of the rules. Okay, kasi kung alam mo yung sharing, alam mo na yung magiging exposure mo sa donor stocks that just in case some of them will actually waive their rights on their share. So malalaman natin yan pagdating natin sa waiver of rights. Okay, renunciation of shares. Later yan sa estate and of course donation. So let's go to disinheritance. Ito yung sinasabi ko sa inyo. You can actually disinherit a person kahit na compulsory heir yan. Under Article 915, a compulsory heir may, in consequence of disinheritance, be deprived of his legitim. Pwede mong hindi bigyan ng legitim yung tagapagmana mo kahit na compulsory heir yan. Okay? But only for causes expressly stated by law. Kung ano lang yung mga babanggitin ko later, yun lang ang mga dahilan where you can disinherit a person. If the cause of your disinheritance is not one of the causes expressly stated by law, then that person can still receive the property. Okay? Article 916, disinheritance can be effected only through a will, wherein the legal cause therefore shall be specified. Kung meron kang gustong hindi pamanahan, sasabihin mo sa will mo na siya ay hindi mo gustong pamanahan. This one is different from preterition. Anong sabi natin kanina sa preterition? The name of the compulsory heir was merely omitted. Natanggal lang siya, posibleng nalimutan or something. But in disinheritance, sasabihin mo, hindi mo siya kinalimutan dito. Talagang inalala mo siya na itong taong to ay tagapagmana ko at ayoko siyang bigyan ng property sapagkat ganito ang nangyari. So, dapat legal cost yan. Pag-usapan natin yung mga legal costs later. Okay, Article 917. The burden of proving the truth of the cause for disinheritance shall rest upon the other heirs of the testator if the disinherited heir should deny it. So, halimbawa, sabi nung tatay mo, hindi kita bibigyan sapagkat ganito ka. If you deny it, the one that will prove, okay, the truth that you are that person shall rest upon other heirs. So it can be your parent or it could, and or your brothers and sisters. Mag-aaway-away kayo dyan. Oh my God. Okay, Article 918, disinheritance without a specification. Hindi sabi mo, hindi mo binanggit ang dahilan if contradicted, is not proved, denied, tapos hindi na patunayan, or which is not one of those set forth in this code, nagtampo ka lang, hindi siya valid na dahilan, shall annul the institution of heirs insofar as it may prejudice the person disinherited. So yung pagkakabanggit lamang ng pangalan ng mga co-heirs mo ay will be annulled. Okay, meaning it's as if all of you shall now inherit. But the devices and legacies, yung binigay pa rin, and other testamentary dispositions shall be valid to such extent as will not impair the legitim. So example, merong free portion na 25%. Okay? Yung 25% na yon, device or legacy, yon pinamigay ng testator. Pero kung ang share mo ay 30%, yung bali, ang nangyari, yung device and legacies are inofficious. It impaired your legitim. Therefore, yan ay mababawasan proportionately. Okay? Next, what are the common causes for disinheritance? Ito po yan. Halimbawa, kailan mo sa first column, imagine niyo to ha, let's say, in the first column, children and descendants, kailan mo pwedeng i-disinherit ang children and descendant? When a child or descendant has been found guilty of an attempt against the life of the testator, yung anak mo o yung apo mo, pinagtangka kanyang patayin. Or yung asawa mo. Or yung anak mo, descendant mo, pinagtangkaan niyang patayin din. Or yung magulang mo, ascendant, or lolo mo. Pwede mo siyang hindi pamanahan. Second column, when the parent or ascendant has been convicted of an attempt against the life of the testator, convicted yan ha. At yung kanina, found guilty, same lang din yan. So halimbawa, yung magulang mo pinagtangka niyang patayin, pwede mo siyang i-disinherit. Sino pa? Yung asawa mo pinagtangka niyang patayin, yung anak mo. Okay, yung lolo't lola mo. O yung lolo't lola mo, ascendant mo, pinagtangkaan patayin din yung nanay, tatay mo, ayan, pwede mo silang i-disinherit. Spouse, yung asawa mo mismo, ang nagtangka sa buhay mo, ayan. Sino pa ang pinagtangkaan niya? Yung mga anak mo. O kaya yung magulang mo. Pwede mo silang i-disinherit. Okay? Next. Anong ginawa ng anak dito? O nung apo, ng magulang, o nung lolo, o nung asawa? Okay? They accused you of a crime for which the law prescribes imprisonment for 6 years or more. Tapos, yung accusation nila ay hindi totoo. It is groundless. It is found to be false. Okay? Ngayon, the question here maybe is that, ano ba yung mga crimes for which an imprisonment for 6 years or more may be imposed? Di ito yung mabibigat na mga crime. Example, murder. Okay? Kidnapping. Sale of prohibited drugs. Yung mga shabu. Yan, more than 6 years yan. Life imprisonment pa nga yan eh. Okay, so sabi ng anak mo, magulang or descendant, sabi ng magulang mo or ascendant, lolo, sabi ng asawa mo, inakusahan ka, you were accused that you killed Magellan. Sabi nila, ikaw ang pumatay kay Magellan. Hindi naman pala totoo. Sapagkat alam natin na ang pumatay kay Magellan ay si Lapu-Lapu. So therefore, can you disinherit them? The answer is yes. Okay, because it's not true. Sabi nila, ikaw ay drug dealer. You are not a drug dealer. Okay, so pwede mo ba silang disinherit? Yes, but what if it's true? If it's true, of course, they can still inherit. Because the requirement here is that it's not true. Okay, next. When a child or descendant, or when the parent or descendant, anong ginawa nila? Has been convicted of adultery. Grabe, yung mahal mo, yung asawa mo, adultery or concubinage, yung asawa mo, inasawa nila. Pwede mo ba silang i-disinherit? Yes. This is one of the causes specified under our law. Okay? Next. Anong ginawa ng asawa? Anong anak? Here, children or descendant, the parent or descendant, tsaka ng spouse. When they, okay, by fraud, niloko ka, violence, okay, violent basta they committed violence, they intimidated you, or meron silang ginawang undue influence, okay, they cause you to make a will or to change one already made. Okay? Niloko kanila. Sabi ng anak mo, Daddy, ano lang po to, waiver lang po to sa school, pinapirma ka. Yung asawa mo, honey, ano lang to, authorization letter to para makuha ko yung ganito na ganyan. Okay, yung magulang mo, ganun din. Sabi niya, ano lang to, requirement to sa barangay. Pinapirma ka ng will mo. So, fraud yun. Right? So, you can disinherit them. Or violence. Or intimidation. Papatayin ka namin pag hindi mo pinalitan tong gumawa ka ng will. Yan ang mga yan. Undue improper influence. Iiwan kita pag hindi ka gumawa ng will at binigay mo sa akin yung mga property. Ano yung resort? What can you possibly do if you are the testator? You disinherit them. Mga walang kwentang mga tao. Mga walang utang na loob. After all that you have done for them, after you have given them your all, tapos this is what they will do to you? Oh my God, you disinherit them. Okay? Ano pa? Yung anak, children and descendants. A refusal without justifiable cause to support the parent or ascendant who disinherits such child or descendant. Okay, sabi dyan, yung children and descendant, kailan mo pwedeng i-disinherit? They refused without cause to support the parent. Halimbawa, ganito po yan. Halimbawa, ako yung magulang nyo. Pinag-aral ko kayo sa Far Eastern University upang kumuha ng accountancy, ng internal auditing. Then you became certified public accountants. You became certified internal auditors. I gave everything to you. Naghihirap ako. Samantalang ikaw yumaman. Tapos, dumating yung point na wala na akong source of income. I have no more money to support for myself. And then I went to you, anak, pwede mo ba akong bigyan ng allowance na 20,000 per month? Total CPA ka naman. And you said, no! You have no reason. Basta ayaw mo kong bigyan. So, can I disinherit you for doing that? Well, sabi dyan without justifiable cause. So, depende yan. Kasi kung bagong CPA ka, nagtrabaho ka, tapos humingi ang magulang mo ng allowance sa'yo, 20,000 daw, ay hindi pwede. Bakit? Yun lang ang sweldo mo eh. Actually, mas bababa pa nga dyan eh. So, meron kang reason. Hello, ba't ka bibigyan ng 20,000 pesos per month? Eh, kung sweldo ko lang, 15,000. Right? So, they cannot disinherit you. But if you are earning, let's say, 100,000 per month or 1 million pesos per month, and the parent is merely asking for a support, let's say 20,000 pesos, and you're not giving them, pwede ka nilang i-disinherit. Okay? So, what happens now? Halimbawa, lagyan natin ng konting kwento to. So, binigyan mo lang, yumaman ka, wala kang utang na kwentang anak eh, yumaman ka ngayon. Sabi mo sa magulang mo, inasar mo pa, here is 25 pesos. Nababagay sa iyo yan. So magulang mo, tinanggap yung 25 pesos. What happened now? Tumaya sila sa loto. And they won. Okay? 100 million pesos. Can they disinherit you? The answer is yes. Because you refused without just cause to support them. Okay? So mga kapatid, ayoko mangyalam sa buhay nyo, but of course, you have to learn how to love your parents. Okay? Mahalin natin ang ating mga magulang, utang natin sa kanila lahat. Although, hindi ko naman, alam ko, I don't know your family background or your history. Okay? If your parents really deserve love, of course, by all means, we should love them. Pero kung pinabayaan ka, so, nasa sa'yo na yan on kung paano mo i-handle yan. Okay? Spouse, unjustifiable refusal to support the children or other spouse. Ayaw ka support. Yung asawa mo, nag-abroad, di ka niya sinusuportahan, at saka yung mga anak mo, ayan, pwede niyong i-disinherit. Okay? Yung spouse lang ang mag-disinherit yan, Next. Maltreatment of the testator by word or deed by the child or descendant. Okay, pinalaki ka ng magulang mo, minahal ka nila, pagkatapos you maltreat them by word or deed. Example ng word, napakawalang kwenta mong magulang. Yun ang sinasabi, wala kang kwentang ama, wala kang kwentang ina. Malas kayo sa buhay. Or deed, the children are trying to hurt the parent. Sinasampal, sinasaktan. Okay? So, pwede silang i-disinherit ng magulang. Here, when the parents have abandoned their children or induced their, okay, abandon their children, pinabayaan ka ng magulang mo, ikaw na anak, pwede mong i-disinherit yung tatay mo, yung nanay mo. Or induce their daughters to live a corrupt or moral life. Grabe, anong klaseng magulang yan? Daughters lang to ha, daughters. They can, this one does not include the sons. Yung mga anak, ibinugaw para magkapera. Ikaw na anak, you can disinherit them. Or attempted against their virtue. Ayan, pinagtangkang rape. You can actually disinherit them. Okay? For the spouse, when the spouse has given grounds for loss of parental authority, yung mga parental authority, maraming cause yan. When a child or descendant leads a dishonorable or graceful life, dito naman mga kapatid, the parents or ascendants can actually disinherit the children and descendants pag ang child or descendant leads a dishonorable, disgraceful life. When the child basically is what? Anong ginawa ni child? Dito po. Anong ginawa niya? Eh di malamang, durugista siya. Dishonorable. Or disgraceful life. Ayan o. Dishonorable. Disgraceful life. Anong ginagawa niya? Okay, naging ano siya, kalapating bababa ang lipan. Sinira niya ang pangalan mo. Ano pa? Parents or descendants naman dito. Loss of parental authority. Okay, for cause specified in the code. Yung parental authority dito, maraming causes yan. Nasa family code din natin yan. Next is when the spouse, siya yung cause for legal separation, pwede siyang i-disinherit. Niloko siya, pinaglalasing siya, so nagsawa na siya sa relationship nila, so that's the reason. Okay. Children and descendants, conviction of a crime which carries with it penalty of civil interdiction. Pag sinabing civil interdiction, basically, the right of a person has been limited. So halimbawa mga kapatid, pag merong namatay, I mean, let's say that the state or there's this person who killed somebody. Okay, so merong civil interdiction yon, merong limitation on that right of that person. Okay, so pag merong civil interdiction, pwede mong i-disinherit. So halimbawa, yun nga, yung magulang, yung anak mo, okay, merong pinatay, merong civil interdiction yan, pwede mo yang i-disinherit. Ganon din. Sa parents or ascendants, the refusal to support the children or descendants without justifiable cause. And the last is an attempt by one of the parents against the life of the other. Yung nanay, pinagtangka. Naalala niyo yung isang balita, I think it was last month, yung wife ay sinunog. Actually, hindi niya sinasadya. I think it was in Bulacan. Okay, bumili ng gasolina, sinindihan yung asawa. That's actually, it's not even, attempt lang yun, kaya lang consummated, so hindi na siya attempt. Okay, so complete crime na yan. So yun ay parricide ang tawag doon, pinatay yung asawa. So kung halimbawa attempt lang ang nangyari, okay, here, attempt lang yan, tapos nagkabati pa rin sila dahil sa'yo, so pwede ka nang mag-inherit. Okay? Kasi nagkabati na sila eh. Pero kung di sila nagkabati, hindi pwede. Okay? Article 922, a subsequent reconciliation between the offender and the offended person deprives the latter of the right to disinherit. Natural, bati na kasi sila. Article 923, the children and descendants of the person disinherited shall take his or her place and shall preserve the rights of compulsory heirs with respect to the legitim. Yung mga na-disinherit, kaya halimbawa, dinisinherit yung magulang mo, Kaya lang, mga kapatid, merong ikaw ay anak. Okay, so apo ka, ang nag-disinherit, lolo't lola mo. Hindi na sila pwedeng magmana. Pero kung halimbawa you are a minor, they can still preserve your rights. Tatanggapin nila yung property not for them to own it, but for them to take care of the property because they can no longer inherit. Disinherited nga sila eh. So, ang gagawin lang, okay, for mere preservation lang. Okay, children and descendants of the person disinherited shall take his or her place and shall preserve the rights of compulsory heirs with respect to legitim. Siyempre, natural, hindi sila pwedeng disinherit na nga tapos sila pa yung mag-aano. Iba makikinabang. So, bawal yun. The disinherited parent shall not have the use of right or administration of the property which constitutes the legitim. Yun ang point natin dito. They cannot, disinherit mo na. Alangan namang sila pa yung makinabang sa property, kaya bawal. Ang magmamana dyan by right of representation are the descendants, yung mga anak. Article 963, proximity of relationships is determined by the number of generations. Each generation forms a degree. Okay, yung kapatid mo, isang ano yan, yung line nyo, you have 1 degree, yung tatay at saka tito mo, kapatid niya, 1 line yan. Okay, later pag-usapan natin, we have an example, prime example for this one. Article 964, a series of degrees forms a line which may be direct or collateral. A direct line is a series of degrees among ascendants and descendants. Paakyat pababa. Ito yung sinasabi ko parati. Collateral, hindi paakyat pababa to. Okay, pero imimit natin yung common ancestor. Later, meron tayong example dyan. 965, the direct line is either descending or ascending. The former unites the head of the family. So, descending, okay, with those who descend from him. Yung latter naman, ascending, binds a person with those from whom he descends. Article 966, in the line, as many degrees are counted as there are generations or persons, excluding the progenitor. Okay. In the direct line, ascent is made to the common ancestor, blah, blah, blah. In the collateral line, ascent is made to the common ancestor, and then aakyat daw muna sa common ancestor. Importante ang common ancestor. And then bababa saan? To the person with whom the computation is to be made. So, a person is 2 degrees removed from his brother. Example, ikaw ito. This is you. Yan, this is you. This is your brother. Kahilera mo siya, kapatid mo siya eh. So, 2 degrees removed. Ang common ancestor nyo, parent. Ayun. Kaya akyat, baba. So, 2 degrees. 1 degree to, 2 degrees yun. 3 from his uncle. Ikaw to, this is you. Ito yung uncle mo, uncle. Ito yung daddy mo. Kahilera ng daddy mo yung uncle mo, tama? Sino yung common ancestor ninyo? Edi yung grandparent. Okay, so isa, akyat. Kasi ito yung papunta eh. Kinukuha mo yung from you to your uncle. So, isa, akyat. 1 is from you to your daddy. 1. Daddy to grandparent. Lolo. 2. Tapos bababa siya kay uncle. So, 3. Ganon siya. Ito yung 1. Ito yung 2. And then 3 to your uncle. And 4 from his cousin. Yung anak ng uncle mo, pinsan mo. O, di yun na magiging 4. Okay, ganyan ang counting sa relationship, sa generations. 967, full blood relationship is that existing between persons who have the same father and same mother. Mga kapatid, ganito po yan. Ang parati nating naririnig is this one, half-blood relationship. Okay, whether your father or your mother, you had a sister or brother from them, magkaiba kayo ng magulang, alam mo, half sister mo siya, half brother mo siya. Pero ang tunay mong kapatid, full blood ang tawag dyan. Kung same father and same mother. Okay, pag magkaiba, half blood yan. Next. Okay, ito yung sinasabi natin. This one, ascending direct line, ayun, papunta dyan. Descending direct line, ito, papunta dyan. Okay, collateral, papunta dyan, or papunta dito. Okay, so mga pinsan, mga kapatid mo, collateral yan. Bakit collateral ang kapatid mo? Kasi hindi naman siya paakyat, hindi rin siya pababa. This is you, and this is your brother. Okay, hindi siya dito, hindi siya sa baba din. So collateral line mo yan. Okay, next. So halimbawa, hinahanap natin ang degree of your relationship with your first cousin. Although nabanggit ko na kanina. So ganito yan. This is you. We're looking at your degree of your relationship with your first cousin. So collateral line yan. Okay, paano tayo aakyat? Ayun, si parents. Aakyat tayo. First degree yan. Pupunta tayo kay lolo't lola. Common ancestor ninyong dalawa ni cousin. Common ancestor ninyo. Okay, so second degree yan. So from grandparents to tito, tita. Ayan, third degree na yan. Yung parent mo at saka yung kay uncle. Ito po. Ayan o. Collateral relative din yan. Okay, so yung tito-tita mo, ayan, papunta kay first cousin, fourth degree mo na yan. So, fourth degree of relationship mo si first cousin. Okay? So, activity, what is the degree of your relationship with your child? Eh di kung if this is you, meron kang anak, this is your child, ano yung degree of relationship? 1. Brother or sister? This is you. Ito yung sister mo na naman, sister. Common ancestor, magulang, parent. Edi 1, 2, pababa. Child of your first cousin, balikan natin to. Ayun, yung anak nito, may anak siya. Pamangkin mo, edi pang ilan mo? 5th degree. So this is 1, this is 2, this is 5th. Boyfriend or girlfriend, ano ang degree of relationship? Wala kayong relationship. Okay? For purposes of determining relationship under the Civil Code of the Philippines. So let's go to legal or intestate succession, brothers and sisters. What is the order of succession? Yung una natin pinag-aralan, compulsory heir. Okay? Papaano kung merong intestate or legal succession? Walang will. Sinong unang-unang magmamana? Ayan, descending direct line. Direct line, pababa ha. Direct. Then we have ascending, akyat. Direct line. So, ganyan yan. Pagkatapos, pwedeng mag-coexist ang illegitimate children, surviving spouse, collateral relative, okay, at saka state. Okay, hanggang dito lang yan. Pwedeng mag-coexist yan. Kasi, sorry, hindi pwedeng magmana itong collateral relative. Sabi ko nga, kung merong descending, kung merong ascending, ito pwedeng magmana. Pero yung collateral relative, magmamana lang to kung wala itong mga yan. Clear? Ito, pwede pa rin naman tong surviving spouse at saka collateral relative. Pwede yan. Pero kung wala na itong mga to, okay, wala na yung mga yan, sila yung magmamana. So, before, there was a question by one of your classmates. Sabi niya, wala na siyang tagapagmana eh. Wala siyang magulang, wala siyang anak, wala siyang mga kapatid. Sila yung magmamana. Okay? Kahit walang will. Pero kung wala na siyang collateral relative, lampas na 6th degree of relationship, ang ating gobyerno na yung magmamana. That is the rule under our Civil Code of the Philippines. So, incapacity to succeed. Mga kapatid, we discussed before who are those who cannot inherit. Ang sabi natin, the persons who cannot inherit or those incapacity to succeed are, number 1, those who are enemies of the state, those who are dead already, those who are fictitious, like cartoon characters. Sabi ko, meron pa na hindi magmamana. Ito pa po ang mga hindi magmamana. Okay? Under Article 1027, the following are incapable of succeeding. Number 1, the priest who heard the confession of the testator during his last illness. Ito yung mga requirement, last illness yan. Kung siya ay hindi naman last illness at siya ay nag-confess, pwedeng magmana yung pare or minister. or any person who extended spiritual aid to him during the same period. Okay? So halimbawa nag-confess or nagbigay ng spiritual aid, okay? Pag yan ay last illness na, nangyari yung confession, si priest at saka si minister, they cannot inherit. Pero kung halimbawa, dati nilagnat lang, okay, tapos nag-confess. Pagkatapos ngayon, may COVID, namatay sa COVID, pwede bang magmana si priest/minister? The answer is yes. Because ang last illness niya ay COVID. Clear? That's the difference. But halimbawa nagka-COVID, pinatawag si father or si minister, tapos nag-confess siya at namatay siya. Tapos bago namatay, binigyan ng property si priest or minister. The priest and the minister cannot inherit. Okay, kailangan merong will. Eh, hindi, bakit? Hindi naman kasi relative si priest at saka minister eh. Okay? Number 2, the relatives of such priest, mga kapatid, hindi lamang si father ang madidisallow dito at saka si minister. Sino pa ang hindi magmamana? Yung mga kamag-anak ni father at saka ni minister up to the 4th degree of relationship. Sino yung 4th degree of relationship natin kanina? Sa example natin, si first cousin. They cannot inherit. Sino pa? The church, the order, chapter, community, organization, or institution to which such priest or minister may belong. Grabe, ang tindi. Hindi lang si father pala, at saka si minister, kung hindi mga kamag-anak, pati simbahan nila, hindi pwede. Yung kanilang komunidad or organization. Okay, bakit may ganitong role, incapacitated to succeed? Because there can be an element of undue and improper influence. From whom? Kay priest or kay minister. Example, halimbawa, there is this person who is dying or who felt like he is dying already. And then, I was called to hear the confession of that person. And then, let's say I am a bad person. O sabi ko, gusto mo bang makarating sa langit? Siyempre, ikaw naman, namamatay, feeling mo mamamatay ka na. Yes ka naman. And then the priest said, if you want to go to the kingdom of heaven, the kingdom of God, you give all your properties to me. Ikaw naman, siyempre, gusto mo makarating sa langit, gusto mong, wala namang mawawala na sa'yo kasi patay ka na, mamamatay ka na rin lang, pumayag ka. Right? Is that possible? Yes. Kasi tatakutin ka ng, there's a possibility that the priest or minister, takutin ka. Kung hindi mo bibigay sa akin yan, ang Panginoon natin, ikaw ay parurusahan. Okay, ikaw ay papadala niya. Pagsasarahan ka ng pinto ni San Pedro. Okay, sasabihin niya, ikaw ay makakarating sa dagat-dagatang apoy. Grabing takutan yan. So, yan ang rule dyan. Okay? Number 3, a guardian with respect to testamentary dispositions given by a ward in his favor. Okay, guardian mo, hindi pwedeng mana sa'yo, incapacitated to succeed. Ang mga guardian, yung nag-aalaga sa'yo na hindi mo magulang. Okay? Unless they are your compulsory heir. So in number 3, a guardian with respect to testamentary dispositions given by a ward in his favor before the final accounts of his guardianship have been approved. Okay, even if the testator should die after the approval thereof, nevertheless, any provision made by the ward, okay, when the guardian, when the latter is his, pag yan ay ascendant mo, magulang mo, o anak mo ang nag-aalaga sa'yo, or sister or spouse, valid yan. Okay, pwede sila magbana. Bakit? Compulsory heir mo sila eh. Pero kung hindi mo compulsory heir si guardian, hindi siya basta-basta magmamana. Kasi there's an element again of undue and improper influence. So halimbawa, ikaw, inaalagaan mo yung isang matanda. Sabi mo, kung hindi mo ko papamanahan, naku, pabayaan na lang kitang mamatay dyan, mag-isa ka lang sa buhay mo. Hindi na kita bibigyan ng pagkain. Di ba that kind of element of influence, right, over the person? Sige, sabi niya, gagawa na lang ako ng will, basta wag mo, bibigay ko sa iyo ang lahat, wag mo lang ako pabayaan. So, this rule under Article 1027 effectively safeguards the right of the testator. So kahit na gumawang ganyan, pwede pa rin silang hindi sila magmamana because it's all provided in Article 1027. Number 4, sino pa ang hindi magmamana? Sabi natin kanina, any attesting witness to the execution of a will, the spouse, parents, or children, or anyone claiming under such witness, spouse, parents, or children. What did I tell you earlier? If your parent gave you something in their will and they ask you to be their witness, right? You, your spouse, your descendant, your ascendant cannot inherit. You will be disqualified. Okay? Kailan ka pwedeng magmana? You can get the property if there are more than 3 witnesses. So kung ikaw ay pang-apat, sabi sa iyo ng magulang mo, sige, pumirma ka dito sa will as a witness. You can agree provided that there are 3 more witnesses. Pag 4 kayong witness, valid yung ibibigay sa iyo other than legitimate. Okay? Pero pag 3 lang kayong pumirma, yung dalawa niyong katulong at saka ikaw pumirma as a witness, you will be disqualified from getting the device or the legacy. Sa legitimate, sa iyo talaga yan. But as far as the additional inheritance is concerned, you cannot inherit. Why? Because you are incapacitated. You cannot inherit. You are incapable. Sino ba ang hindi pwedeng magmana? Number 5, yung doktor, surgeon, physician, nurse, health officer, or druggist who took care of the testator during his last illness. Mga kapatid, example na lang natin ngayon since uso ngayon yung COVID. All of these people who took care of you, let's say the testator during his last illness, okay, they are not allowed to inherit. Kasi nga, there's an element of improper and undue influence. Ang lakas niyan. Halimbawa, ikaw, o wag na ikaw, si Nicanor, nagkaroon siya, was inflicted with a COVID-19 virus. Tapos nasa ospital ka. They know that you are rich. Tapos sasabihin ng doktor, nakikita mo ba itong hawak ko? Gamot ito. Laban sa COVID. Okay? Kung hindi mo ako papamanahan, hindi ka gagawa ng will, hindi kita bibigyan ito. What will be your choice if you are the testator? Di sulat ka lang, tapos bigyan mo siya. Right? And number 6, individuals, associations, and corporations not permitted by law to inherit. Mga kapatid, sa ating civil code, the revised corporation code of the Philippines, merong mga restriction dyan as regards to those people who are not permitted by law to inherit. General rule, bawal silang mag-inherit. Okay? Pero merong restriction sa revised Corporation Code of the Philippines na po yan. So, unworthiness. We are on our last part. Article 1032, the following are incapable of succeeding by reason of unworthiness. Mga hindi karapat-dapat magmana. This is different from the causes for disinheritance. But there are cases where it's mostly the same. Yung disinheritance, you are being disinherited because you did this or you did that, the legal causes. Ito naman, hindi ka rin magmamana dahil ikaw ay hindi karapat-dapat. They are different although their provisions or requirements are basically the same. Okay? Example number 1. Yung magulang mo, parents who have abandoned their children or induced their daughters to lead or a corrupt or immoral life or attempted against their virtue. Are you familiar with this one? Yes. I've mentioned already this provision in the valid disinheritance. Right? Pinabayaan ka. You were induced to lead a corrupt or immoral life, yung mga babae. They tried to rape you. So, pwede mo silang i-disinherit. Kung hindi mo man sila i-disinherit, pwede silang hindi magmana because they are not worthy to receive it. Okay? Pero mas maganda pa rin, i-disinherit mo pa rin para maliwanag. Okay, number 2, any person who's been convicted of an attempt against the life of the testator, parehas nung kanina, parehas yan. Any person who has accused the testator of a crime for which the law prescribes imprisonment for 6 years or more, tapos hindi totoo, parehas yung kanina. Any person of full age who have having knowledge, eto bago to. Okay, full age, nasa tamang edad ka na, tapos nalaman mo may violent death, pinatay pala yung testator, hindi mo siya ni-report sa pulisya sa loob ng 1 buwan, grabe ka, sama mo. Okay? Pwede kang hindi mag-inherit yan. Bakit? Hindi ka karapat-dapat, you are unworthy. Unless the authorities have already taken action. Okay? This provision shall not apply to cases wherein, according to law, there is no obligation to make an accusation. Okay, so meron na rito nag-take over na yung mga police, so wala ka ng obligation dyan. Number 5, any person convicted of adultery or concubinage with the spouse of the testator, katulad yan ng kanina. Grabe, yung mahal mo, yung asawa mo, minahal din, nino, naku naman. Ng mahal mo, di ba? Number 6, any person by fraud, violence, intimidation, undue influence should cause the testator to make a will or to change one already made. Halos parehas kanina. Mga kapatid i-relate lang natin yung number 6 sa law on obligations and contracts. Kasi ang familiar nyo yung FIVUM. Right? Ano yung FIVUM? Fraud, intimidation, violence, undue influence. Ito, mistake. Walang mistake dito sa number 6 ha. Fraud, violence, intimidation, or undue influence should cause the testator to make a will or to change one already made. Itong mga to, one that vitiates the consent under the law on obligations and contracts. Number 7, any person who, by the same means, prevents another, dito pinigilan mo gawa ng will, from making a will or from revoking one already made, or who supplants, conceals, or alters the latter's will. Okay, dito naman, yung una, pinigilan mo gumawa ng will o para baguhin yung will. Okay, yung una, pinigilan mo kasi baka mamaya hindi ka bigyan. Yung isa, from revoking, pinigilan mong i-revoke kasi baka mamaya nandun ka sa will na yon, baka tanggalin ka. Or who supplants. Okay, supplant or conceals, tinago, or alter, binago mong will niya, pwede kang hindi magmana. Bakit? Hindi ka karapat-dapat. Number 8, any person who falsifies, naku naman, or forges a supposed will of the decedent. You are unworthy of succeeding. So that is actually the end of our presentation for the rules on succession. So thank you very much, brothers and sisters. This is a recording which I will share to your class already.